Meet Joe, an industrious entrepreneur. He is like many other entrepreneurs, investors, and professionals who have some money in the bank because he is a target for one of the more than 40,000 lawsuits filed in the U.S. every single day. Lucky for Joe, he set up a portable asset protection trust with his attorney, Wayne Patton. Joe's Portable Asset Protection Trust, also known as a springing trust, was based both in the United States and in the Cook Islands. This means that Joe remained in complete control of his assets. He also avoided expensive annual trustee fees and mandatory tax filing requirements for offshore trusts that often cost between $7,000 and $10,000 per year. Joe's trust was also much better than a Domestic Asset Protection Trust, or DAPT, because it gave Joe the option to move his trust and assets completely offshore if he ever faced a potentially catastrophic lawsuit. Besides that, Joe had learned that most U.S. states have public policies against DAPTs and that several DAPTs have already been busted in court. Then, on one random day, it happened. Joe was sued. It could be any lawsuit for any reason: malpractice, a slip and fall on his property, a disgruntled former employee, a traffic accident, business deal gone bad, or even a totally frivolous claim. Joe called his attorney, Wayne Patton, in a panic and was relieved to hear the words, "Don't worry, Joe, you're protected." Joe's Portable Asset Protection Trust was triggered, meaning that it moved offshore across the legal bridge connecting it to the Cook Islands after years of being in the United States under Joe's sole control. Many of the liquid assets inside the trust were also transferred to international bank accounts, so that the trust itself and the assets inside the trust were all beyond the reach of U.S. creditors. Joe was even able to protect his real estate inside the trust. And all the assets were still available to Joe and his family for their needs. Of course, this was entirely legal because Joe's plan had been put in place before any lawsuits were filed against him. If Joe had waited until the lawsuit had been filed, his asset protection options would have been severely limited. When the attorney suing Joe found out about the asset protection plan, that attorney suddenly felt very motivated to settle the case against Joe for pennies on the dollar. Even if the attorney had decided to continue the suit and eventually won in court, the Cook Islands trustee would simply refuse to hand over Joe's assets. Again, the plaintiff's attorney would be forced to either take nothing or accept a very low settlement offer. These outcomes made Joe feel very secure about his ability to provide for his family, even in the face of a lawsuit that otherwise could have devastated Joe's finances. If you'd like to protect your assets so that you can feel true financial security and peace of mind like our friend Joe, please call Wayne Patton today for a confidential attorney-client privileged consultation.